Hello, everyone. Welcome to SeniorOpedia, the everything how-to guide for seniors and caregivers. I'm Veera Falawala. I'm going to be your host for today's episode. Now, for today's episode, the plan was to talk about wills. But as we started to dig into that topic, we found that, wow, this is really a big topic and a broad topic, and there's lots of different aspects to it. So what we're going to do today is we're going to have a bit of a primer, just as a 101. We've brought in an expert who can talk about the various facets of it, where to get involved, what to get involved. And so I welcome here today Trupti Panchal-Smit. She is an estate planning lawyer as per her profile. Welcome, Trupti.
Thank you. It's so nice to be here, and I'm really excited to talk about something that's dear to my heart, which is wills. I think as a lawyer, we see a lot of scenarios happening, and I'm at a stage in my life where I am seeing the need for wills because my father passed away actually intestate by choice, and I went through that experience. I have friends who are also going through the experience of having parents passing away. Sometimes there's real estate, sometimes there's private shares. And I have witnessed friends and family scrambling and struggling after a parent has passed away. And so I'm here, and my practice is focused on helping people avoid those pitfalls and help families feel and help people feel confident and a peace of mind. And that's what I've experienced when people go through the will process with me. They have a sense of relief, a sense of confidence that they've finished this important process. And so that's why it's something that I do advise people on strongly.
So your title is estate planning lawyer, and that's the first time I've actually ever seen that planning be incorporated. Normally, I just see estate lawyer. Is there something different or more that you bring to the table that you add on to your services that warrants the planning?
So wills and estates, there's two parts to it. One of them is making sure that your wishes with respect to your property are respected or followed when you've passed. When you're not around, you want your family to have a guide what to do with your belongings once you've passed. The other part of it is the tax side. So when you pass, the CRA deems that as a full disposition of your assets. So there's a tax impact. I have a tax background. I've been practicing in international and Canadian tax for over 11 years. And understanding the tax impact at the time of a deceasing event is really important to plan for your estate so that you know and you can protect the estate that you are or your legacy that you're passing on to the next generation.
Okay, so as I understand it, there, if you think of it like a flow chart, it kind of you come in with the planning part of it because you do have to plan for the future. And then it breaks off into two parts. One is the actual implementation of what you do on the legal side. And then the other part of it is what you're going to do on the tax side. But if you don't plan for that up front, you may end up having more money going off to the government than need be.
Exactly. And that eats away at your estate, and it's funds that could otherwise have gone to your family, to your children, to your grandchildren, and instead it goes to the CRA. So that's where the planning comes in, is to make sure that we are maximizing the value in your estate and there isn't unnecessary tax leakage.
Now, I've got two sisters, and then there's myself. And when my dad passed away years ago, I remember because I was his executor, he asked me to make sure one thing, make one promise to me that the government is not going to get any more money than they absolutely need to out of whatever I've saved up. And I want that money to go to you and to the other kids and to their grandkids as well. So I guess that's what you're really talking about.
Exactly. And it becomes very relevant if you have different categories of assets. So say you have residential home, your primary home. Let's say you have a cottage, or say you have a business, or you have some shares, say you're a partnership maybe. So you have shares in a private corporation. So we look at the full range of your assets and liabilities, and I'm able to then help you understand what would be the probate impact, the tax impact, particularly with capital gains impact, if there was a death event.
You mentioned a few different things. We got wills, certainly. We've got, I said executor. You said probate. There's so many terms here. Can we just kind of walk through the journey of somebody who starts off in a healthy position, maybe when they should start thinking about their wills, and then kind of walk our way through the entire process until the end? And what are the different roles and the different terms that are being used?
Yes, great question. Um, look, we've looked at the numbers, and people who are, let's say, in their early 20s, 20 to 30 year old bracket, seem to be less concerned about having a will. We find usually when someone's gotten married, and usually when there's a child, this seems to really ignite an interest on having a will, of course, because now they have a child. So they have someone that they might need to bequest their property to and make sure it's protected in the event something happens to them. But at the same time, there is a benefit of having a simple will in place regardless. The benefit is
even
that
even in your 20s and 30s.
even in your 20s and 30s, if you at least have started the process and you've appointed an executor, then your estate is protected to some extent probate tax. Not having an executor means that you die at an intestate, which is not a great scenario, because then nobody knows, nobody has the authority to close your bank accounts, to deal with your digital assets, to deal with your car maybe, or if you have a house or a condo, if you're, any other matters that could be relevant for you, nobody would have the authority or the instructions on what to do. Having said that, for sure, after you have a child, this is definitely for me. Once I had my child, that was definitely when I decided I needed to get a will. And when I went through that process, I did feel a lot better at the end, knowing that, okay, if something happens to me or my husband, my son is taken care of. It also helped me decide on who my executor is going to be. So who do I trust to be organized and to be diligent in managing my affairs if I'm not around. I was able to have that conversation with that family member and develop that kind of understanding that if something happened to me and my husband, like, this is what we want to happen and this is how the will is structured. So selecting executor is really important. Also, having selected your beneficiaries, sometimes it's evident. Of course, the law does cover that if you pass away, then all the belongings will go to your spouse. And if you're not your spouse, then to your children in equal proportions. If you have any other wishes, if you have pets, if you want to give to a charity, if you have nieces or nephews that you want to also bequest to, those all have to be specifically identified and written up in a will. And then the assets. Without a will, there's no tracing, there's no capture of what your assets are and what to do with it. So when you go through the will process, it is taking an inventory of your assets and giving those clear instructions on what to do.
And you mentioned in their executors, so they're the people who are going to be executing your plans that you have laid out in the will of who I want to go where. But you said automatically it goes first to your spouse and then to your kids as well as any of the value of the assets. So does that mean that if you don't have a will, it's okay?
We do have what's called the Succession Law Act. So if you die without a will, there is legislation that then dictates what's going to happen to your estate. And there is very little room to maneuver from that. Having said that, your family members would need to go to court to get a certificate of authorization or administration to actually then deal with your estate assets. So
So
there's
even your
process.
spouse and your kids would have to go through that court process to get it without a will.
Yes, and your estate will be subject to 1.5% probate tax. So that'll come right off the top.
Is that going to happen regardless of whether you have a will or not?
No. So if you have a will, you've designated your property in your will, then you're avoiding that 1.5% estate tax.
Interesting.
In most cases, there are some exceptions depending on the assets in the scenario, but that is the big reason that you want to have a will.
And so as things kind of progress, you get a little bit older and things like that, your health perhaps starts to fail. Now you got a power of attorney. And that's different for your executor.
That's right. So a will is what we call a testamentary will that comes into effect after someone has passed away. But also, while you're alive, there could be a situation where you're incapacitated. And you need someone to be able to, for example, pay your bills, maybe speak to the doctor on your behalf. So for this, we have what's called a power of attorney. We can also put in a continuing power of attorney or one that activates upon a certain event. But a power of attorney is really important to have kind of, in your filing cabinet that is there in the event that there is that sort of an emergency. We just had a client where the father had a stroke. It was his second stroke within 2 weeks. He was hospitalized, but he had been relatively, incapacitated. He was coherent, but he wasn't able to make his payments, his bill payments, his mortgage payments, because there's nobody to do that. And his daughter couldn't do it. And then so she approached me. She said, I think my father needs a power of attorney because all these things are going into arrears. He was already in the hospital. And we're now waiting for the doctors to give us clearance that we can go and see him and get instructions when possible. So they're in a bit of a financial crunch now because there isn't that power of attorney in place.
Wow. So that's got to be a terrible thing, both for the family, the person themselves.
And so, just like we take vitamins and whatnot as preventative care, having a will and going through your estate planning process, it's preventative, right? It prevents hardship and confusion for your family later on, and it prevents decisions and omissions, prevents that from being made in your absence without your ability to make that decision. So it keeps you in control, and it keeps it very clear what's going to happen.
Is this also where a trustee gets involved, or is that a different?
So that's a great question. I love trusts. I do all kinds of trusts. I put in family trusts for families who need it. So there are trustees in different capacities here. If you have minor children, your trust and your will be set up so that there would be a testamentary trust that gets established, and and we would designate a trustee who could also be your guardian for your child, for your children. Technically, an executor is a trustee. They have the same responsibilities. They have a fiduciary responsibility to act in the best interest of the beneficiaries. That's the job of the executor and trustee. They're not in it for themselves. It's not a job. The purpose of their role is to protect the rights and to act in the best interest of the beneficiary, which is also what your will is for, right? Your will is for
Right.
the best interest of your beneficiaries.
So a trustee can be there when you're alive as well as after you've passed.
Well, in the will scenario, a trustee or an executor would come into play when you've passed. There are other kinds of trusts like bear trust and family trusts or inter vivos trusts, as we call them, which are called living trusts. In those scenarios, we would have a trust while you're alive. But in the will scenario, the trustee would come into effect after you've passed away.
Okay. And from what I understand, there's a different power of attorney or perhaps the same person that handles both health and financial side of your
Right.
estate and assets
Yeah.
and things like that. So how do you pick the right trustee, or how do you pick the right executor for any of these roles?
Yes, this is always the biggest question that we start off with. The way I guide my clients is we talk about, first of all, we go over their assets, and we go over, what needs to happen, what would need to happen in the event of a death. And then we talk about, well, do you have any siblings? who is it in your close family or friend circle that you can depend on to carry out your wishes, right? They need to be organized, they need to be responsible, and they need to be able to act in the best interest of all the beneficiaries. So yes, very often it's a family member, maybe a sibling or another relative. We also suggest, and I usually have clients provide a substitute, so a backup executor in the event that the assigned executor either can't act or isn't willing to act. Maybe they're no longer in the country, maybe their life circumstances have changed. So to protect the estate, we also ask for a backup executor. There's also options for some people tell me that they really don't have anybody that they can list as an executor. There are trust companies and there are law firms. We also can act as an executor. So you can assign, your lawyer, you can assign me, for example. And there's also, like I said, a third-party trust companies that you can assign as an executor.
Isn't an executor obliged to take on the role? What if they don't want to have anything to do with it? It's too much for them.
Great question. I remember I had a friend a while ago who he was an accountant and said, "Oh, I was the executor for someone's will, and now I have to, administer the will." And it was a lot of work. And I said, "Oh, was this something that you would agree to?" And he's like, "Yes, I did." But at the time, I think maybe he didn't realize kind of what was involved. So there is this question mark, on whether your executor is going to be able to do this work. For that reason, I do suggest clients to speak to whoever they're intending to maybe select as an executor. And like I said, as long as it's somebody that you can trust and that you've spoken to them and that they're responsible, usually, and the benefit of using a lawyer to help you with your will is that we can then also help your executor. You might need to arrange for a sale of property. You might need to arrange for a transfer of ownership. You may need to arrange for, bank accounts and closing, and it can become a bit of an administrative nightmare depending. And, this is why I'm really glad that Transition Squad exists, because often it's in the contents, right? The
Yeah.
executor needs to deal with the contents of the estate, the contents of the house, the contents of the cottage. So it can become a bit of an administrative, I don't want to say nightmare, but it can become a lot of work.
It is
Part of what
a
really
lot of work, right? When you're
is
dealing
a
with the
lot.
content, because you're dealing with a whole bunch of small things. It's one thing to deal with the house. You hire your real estate agent, they take care of it as one thing, right? Same with a car. But when you start dealing with the scads of things that people have collected over 30, 40, 50 years that are sitting in their house, and you've got to get rid of it. And you've got to do it in a proper fiduciary way so that you're maximizing the value back to the estate.
Yes. And so this is the other benefit of going through a will process is we then take the time and we ask the client to list their most valuable assets to indicate what they want to get inherited by whom. And that actually helps the process on what to do with the contents afterwards. So when the family comes to you to do that step, it's a little bit easier that they have a little bit more direction. I think that's probably where it gets difficult and confusing is that your family, after you've passed away, there's questions. What do I do? Should I do this? Should I do that? So I take some time to do an inventory with my clients. I ask them to take pictures of, let's say, jewelry that they want to bequest, maybe watches or any, heirlooms, anything of value that they want to specify. I help them categorize those, catalog them, and make sure we've probably indicated in the will what the wishes are.
If somebody needed to get a hold of you to either do their own will or just for general information, where could they get a hold of you?
So I'm with Luxaltico, and you can easily get a hold of me by email at Trupti, Trupti, at Luxaltico, LEXALTICO.com. You can also reach me by phone at 416-907 6011. And you can reach me on LinkedIn you can find me at Trupti Panchal-Smit, and you can visit our website at letsaltgo.com.
Trupti, thank you very much for your time today. If you like this episode, then subscribe, like, share, and most importantly, register for upcoming notifications at SeniorOpedia.com.